Could I have your attention, please? Thank you. Executive Deputy Commissioner Green, welcome. We're glad to have you here. We look forward to your testimony.
Thank you. Good afternoon, Chairwoman Young, Chairman Farrell, and distinguished members of the legislature. I'm Mike Green, head of the Division of Criminal Justice Services, and I appreciate you having me here today. Governor Cuomo's proposed budget for fiscal year 2016-17 will allow DCJS to support the criminal justice system in communities across our state, expand the use of evidence-based programs proven to be effective and cost-efficient, and continue the development of innovative programs that position New York as a national leader in effective public safety policy. New York continues to experience reductions in crime and prison population. Reported crime reached an all-time low in 2014. In that year, we maintained our standing as the safest large state in the country. New York also has the lowest imprisonment rate of any large state. Statewide crime data is not yet available for 2015, but preliminary trends indicate that crime continued to decline. We will have better numbers by mid-spring. In addition to reintroducing legislation to raise the age of criminal responsibility, the governor has proposed a range of other reforms to enhance the fairness and effectiveness of our criminal justice system and build trust between law enforcement agencies and communities. In his Build to Lead agenda, Governor Cuomo advocates for legislation requiring recording of interrogations in serious cases and reforming identification procedures to bring New York in line with 49 other states that allow photo array identifications into evidence at trial. Law enforcement agencies have embraced recording, and we've already provided approximately $3 million for them to purchase and install technology. DCJS plans to announce additional funding this year. The Innocence Project and District Attorneys Association support these concepts. It's time they became law. The governor is also committed to reforming New York's bail statute. New York is one of only 4 states that prohibit judges from considering risk to public safety as a factor when setting bail. A common sense amendment will allow judges to consider that risk when setting bail or allowing release, and permit them to use proven risk assessments to aid in pretrial release decisions. Other jurisdictions that have successfully implemented the use of risk assessments and have resulted in fewer individuals being detained pretrial, as well as increased public safety. Through the Pew MacArthur Results First initiative, DCJS has strengthened the state's community-based alternative to incarceration network, funding programs that are effective in reducing recidivism and cost-efficient. We are training ATI providers, in addition to implementing a fidelity and evaluation system to ensure the programs we fund are delivered as designed. New York's ATI realignment work has been touted by Pew MacArthur in a recently published case study as a best practice for other states to follow to reduce recidivism and maximize taxpayer dollars. The governor's budget invests nearly $26.2 million through DCJS in programming that reduces incarceration and recidivism. That figure includes new funding, $1 million to expand the state's reentry task forces, to include new task forces in Queens and increase the capacity of existing task forces, and $1 million to create new defendant screening and assessment programs in jurisdictions outside New York City. In its second year, New York's Gun-Involved Violence Elimination Initiative, or GIVE, supports the use of proven strategies to reduce shootings and save lives. GIVE targets the 17 counties that collectively report 87% of the violent crime outside of New York City. GIVE provides police departments and their county law enforcement partners $13.3 million in funding in addition to training and technical assistance from national experts to help implement programs proven to be effective. New York is unique among states in its commitment to funding only evidence-based work through GIVE. The initiative's emphasis on procedural justice, which focuses on ensuring that interactions between law enforcement and individuals are fair, and that individuals who come in contact with police believe they are being treated fairly and respectfully, also sets GIVE apart. More than 200 law enforcement professionals recently attended a 2-day symposium to help them put procedural justice into action. Research shows that positive police-community relations contribute to safer communities. To help stem the tide of gun violence that continues to claim too many lives, particularly those of young men of color, DCJS encourages GIVE jurisdictions to implement street outreach work into their strategies. We provide additional funding to support street outreach in 10 GIVE jurisdictions and in the Bronx. The governor's budget proposal funds GIVE and street outreach work at the same level as the current budget. This 2016-2017 budget proposal will allow DCJS to continue supporting our local partners, expanding our evidence-based work, and implementing initiatives designed to foster fairness, respect, and transparency in the state's criminal justice system. I thank you for the opportunity to speak today and be happy to take any questions you have.
Thank you, Executive Deputy Commissioner Green. Our first speaker is Senator Gallivan, who is Chair of the Senate Crime and Corrections Committee.
Thank you, Madam Chair. Good afternoon, Commissioner.
Good afternoon, Senator.
I have questions in 3 different areas that is outside of the testimony that you just gave us. And you may or may not be aware, and if this is not your area of responsibility, if you can point me in the right direction so I can follow through.
Sir.
2 years ago, in the 2014-15 budget, there was language in that budget to provide for a statewide law enforcement records management system. And the goal, of course, was to do a number of things, to increase the ability of law enforcement agencies statewide to interact with each other, streamline reporting, help them provide better service in the areas of case management, things like that. What is the status of that?
I am aware of the issue you're speaking about, and it's an issue that involves both DCJS and the New York State Police. The state police side of it, and I'm sure the superintendent can address this better than I do, is that their records management system needs to be updated. The technology that it's built upon, as I understand it, is on the verge of becoming unsupported. That basically the same records management system through DCJS is offered to local law enforcement agencies. And at one time, there were well over 200 local law enforcement agencies that took advantage of that offer and used that as their records management system. Again, that same system has the same problems as the state police one, and that the technology was becoming unsupported 2 years ago when that proposal was put forward. That proposal was subject to the approval by the legislature of a plan submitted to the legislature by the executive. The state police and DCJS put together that plan, submitted it to the legislature. We've met with legislative staff repeatedly, and it's my understanding to this date there is still not legislative approval for that plan. What's happening on the ground in the meantime is I have local law enforcement agencies calling me literally every week saying, I need a new records management system. Do I need to go out and buy my own records management system, or is this ever going to happen? Just last week, I received an outreach from the Sheriff's Association asking me the same thing. So I really appreciate you raising the issue. I think it is an issue that needs to be addressed urgently, and we're still waiting for approval.
I was aware, I think it was over late last session and into the summer, perhaps into the fall, I was aware that there was discussions that were ongoing. Has there been recent discussions over the past several months, to your knowledge?
I have not personally heard anything from the legislature. I've met, I'd say at least 3 or 4 times with staff. We've answered questions in person. We've responded to all the written questions that we've received. So I'm not aware of any unaddressed inquiries from the legislature to DCJS.
How can I find out where this is, the status of it?
Again, to the best of my understanding, and I have been following this on a weekly basis because of the inquiries and the concerns I get from local law enforcement, is that we're just waiting for approval from the legislature that the RFP is drafted and ready to go. The RFP was provided to the legislature. The plan was drafted. It was amended a number of times in response to concerns that the legislature raised. The plan was provided to the legislature. So, everything is done, ready to go, and the RFP is waiting to go out the door, and the only thing we're waiting on is the legislative approval.
All right, thank you. The next question does have to do with the governor's budget proposal this year, but more so pointing to last year. So in last fiscal year, there was $60 million allocated. The category was for law enforcement safety equipment, but it was to include vehicles for state police and then some other equipment, bulletproof vests, things of that nature. There was a recent news article within the past 3 or 4 weeks where a spokesperson for the governor said that money was contingent on the legislature reaching an agreement with the governor on last year's various criminal justice proposals. I was in on many of those meetings. I don't recall any time that funding was contingent when we put that budget forward. So this year's budget essentially takes that $60,000 for badly needed state police cars, for badly needed equipment and the other things, and reallocates it for different things. I do know that there was a much smaller amount allocated for equipment. I think it was $4 million or something of that nature. Are you able to comment on that and maybe alleviate our concerns that the state police does not need vehicles, does not need additional equipment?
First of all, you would certainly have better information than I in terms of what was said in the negotiating sessions. I wasn't there. I am well aware of the $60 million you talk about. What I can tell you is that money was never provided to DCJS. Originally, there was conversation about DCJS doing RFP or solicitation for local law enforcement. I know one issue related to the appropriation language, the way the language was drafted. It did not give DCJS the authority to pass that money through on local assistance grants. I know that the executive and DCJS provided input as to language that would fix that problem, and it's my understanding that language never made it into the bill. I do know that the state does invest through other sources in, for example, bulletproof vests and other funding sources that law enforcement can use, but that $60 million has never come to us for distribution.
Fair enough. Where can you point me to get answers?
Again, I think there were negotiations between the executive and the legislature, and I know one of the things that would need to be fixed is that appropriation language.
All right, thank you. Last question has to do with an overall small item in the state budget, but very significant for some of the local law enforcement agencies that enforce the navigation law. The governor's budget calls for a reduction in reimbursements to those specific local agencies that provide those services, and some of the Finger Lakes, Lake Erie, Lake Ontario, agencies like that. The budget, the reduction was from 50% to 25%. In the overall scheme of the state budget, $1 million is not significant, but to these local agencies, it's huge. Some of them have expressed to me they won't have the ability to provide the enforcement of the navigation on these various bodies of water. How can you suggest we deal with that?
Again, I do not believe that is through the DCJS budget because I'm not familiar with that, and I believe I know our budget fairly well. But I can certainly look into it and get you information on what budget stream that is in.
All right, thank you.
Assembly?
Yes. Assemblyman Joe Lentor. Chairman Joe Lentor.
Thank you, Chairman Herman Dennis Parra. And thank you, Commissioner Green, for the work that you've been doing. I've been watching you, and I admire all the work that you've done in this job. I just wanted to digress from some of the questions that I wanted to ask you because of some of your testimony and following up on what Mr. Gallivan asked. And I guess the first thing I'm going to ask is about the cloud that he discussed. And we have had and we have sent letters over to you regarding some issues that we'd like to resolve in order for us to get on board with some legislation that's needed either independently or in the budget. So I'm just hoping that you'll be able to meet with our staff, that your staff will be able to meet with our staff to clear up some of those issues.
And I'm sorry, I missed, you said with regard to what issue?
With the cloud,
I guess when you say cloud, I really don't know what you're talking about. The issue is a records management system.
Yes.
It's not a cloud. We have met every single time we've been asked to meet. We've reached out and asked for meetings. To my knowledge, we've answered every single inquiry, and I will make myself available at any time going forward to meet with you, your staff, or anyone else from the legislature with regard to the records management system.
thank you. That's all I can ask. And secondly, I'm very perplexed by the governor's commitment to reforming the bail statute, because the mayor of the city of New York as well, it's not only the governor, have proposed issues like the governor is proposing with respect to public safety being required and having a statutory change in order to include public safety in bail reform. At the same time, trying to implement a program to allow people to get out rather than on bail, as opposed to having them languish for 2 or 3 years and then committing suicide like what happened in the case in the Bronx. And so I don't want to ask a long question, but I know historically that, and I don't know if you were here to hear Mr. O'Donnell's questions earlier.
Yes, I
about
heard
bail
the
reform
questions.
and how we know that judges take into account all of the things involving public safety when they set bail. So my most important concern is that this will prevent the judges from letting anybody out if they have a new component that's added to the statute regarding risk assessment or public safety. Because I don't know, some of the judges that I've seen aren't brave, and they might take the position, well, the legislature just passed a statute that we have to take public safety in mind, so why should I let anybody out who comes before me?
I think that's a very
question.
good question. And I know you've spent a great deal of time both in and dealing with the criminal justice system, as has Assemblyman O'Donnell. And I think that sometimes your first instinct is to say, well, if you let judges consider that type of risk, we're going to hold more people. And certainly I could admit that when I first heard the issue, that was one of the things that crossed my mind. But I'm a firm believer in evidence-based work. I think that we need to constantly look at our system and see how can we make it better. I think we need to look at what's happening in other parts of the country in terms of new practices that have been studied and shown results, and see what we can learn from them. And this is one of the areas where I think we can learn. If you look at, for example, some of the work the Arnold Foundation has done, where you allow judges to consider that risk, and at the same time you provide a framework. So right now, assuming Assemblyman O'Donnell is true, and I certainly can't tell what's going on in the mind of judges, but I have to say that I think the inference that he asked people to draw is reasonable. Then you have judges right now with no guidance, no legislative authority considering that risk. I would argue that it's much better to put it in legislation, establish guidelines, and then allow judges to use evidence-based, validated risk assessment instruments as a tool, not to replace their judgment, but as a tool in addition to their judgment, and train judges and prosecutors and defense lawyers on how to use those instruments. And what the evidence has shown in the jurisdictions that have done that is that you actually end up holding fewer people, not more people, and at the same time you have fewer crimes committed by people who are released because you're making better decisions as a system as to who to release. And, you know, to your point about judges being concerned or not wanting to take a risk, if you have valid risk assessment instruments, in some cases that may give the judge the cover that the judge feels he or she needs to make that decision and release somebody who doesn't pose a public safety risk and could safely be released.
Just to let you know that I'm kind of a student of history because my father has been here before I was. And he was here during the 1965 revision of the state penal law. And when the Republican Party controlled both houses of the legislature and the governor was a Republican. And at that time, the penal law was amended by a sentencing commission, I guess, or a law revision commission that was basically head by Mr. Bartlett, Assemblyman Bartlett, who was a Republican member, I guess, from Ms. Dupree's district, I'm not sure, upstate New York. And that commission recommended, after a long, arduous discussion about the issue of preventative detention, that we should leave it out of the penal law. We should put in provisions to allow judges to make the assessment based on the risk factors that Mr. O'Donnell mentioned earlier about it, so that judges' hands wouldn't be tied by a preventative detention statute that would require them to set bail, high bail in most every case. I just wanted to point that out to you because that was done in 1965 when the penal law was revised. So,
from the question, it sounds like you have an advantage and it may be a little bit older than I am.
just a little bit.
But I think that that's a good point, that we should learn from history, but I think we also have to learn from the experiences, and I'm not sure that the science behind risk assessment that exists today existed back then when they were making that decision. And again, if you look to jurisdictions that have implemented this and implemented it properly, the result is fewer people being held. And back to your initial statement, you know, this proposal is being put forth by the governor because of his belief that if we make better decisions and we use the science that's available, we can hold fewer people and make the state safer.
All right, I want to move on, but I should also point out, which I forgot to mention, that at the time in 1965, we had a crime rate that was much worse than today when that decision was made. But let me move on to the independent monitor, because we talked about this last year when you were here, and I don't want to ask a whole host of questions, but it's hard for me to understand whether this was a mistake to be put back in the budget or not, because since the governor issued an executive order to allow the Attorney General to act as a special prosecutor, and an independent monitor would have no resources at all within which to work, and the Attorney General would have a multitude of resources to handle these cases. Why are we asking again for an independent monitor, and why not let the Attorney General handle these cases as a special prosecutor?
To address your first point, it is not a mistake that it was put back in. I think, at least from my position, I think the governor made clear last year that he believed that the best option was the legislative option that he put forward. You know, as I know you're well aware, there are many very important considerations to be balanced here. One of those is that every county has an elected district attorney that the people of that county elected to handle cases like this and make decisions like this in their county. And a countervailing consideration is public confidence in the criminal justice system, which we know is critical, you know, for a number of different reasons. One of which is studies show that when public confidence in the criminal justice system erodes, one of the things that can follow is lawlessness and higher crime rates. So in balancing those things, the governor put forth a proposal that would not automatically take away the district attorney's ability to handle cases, but would put a provision in place when the district attorney either did not go to grand jury within a reasonable time on the case, or the grand jury issued no bill, to have an independent monitor come in review the facts of the case, review the grand jury proceedings, and make a report to the governor. So when the governor exercised his or her powers in terms of whether or not to appoint a special prosecutor, it would be made based on solid information about the facts and circumstances of that particular case. And if the governor felt that there was an injustice or that there was new evidence, the governor could appoint a special prosecutor. And I don't agree with your assessment that there would be no resources, because I think that it is envisioned under that proposal that both the independent monitor and, if necessary, the special prosecutor would have the resources necessary. Now, last year, the governor made clear that that was his preference, but that if it didn't pass, he felt something had to be done. And when nothing was passed, he felt something needed to be done. He signed the executive order. We're obviously in a different position this year. You know, now there's an executive order in place, but that doesn't change the fact that the executive feels that the best path forward is a path that creates that balance between those two very important considerations. And I believe that that is the reason why this legislation is put back in again in the governor's Article 7 budget.